David Maraga has joined calls from the civil society for a refund of public funds spent on President William Ruto's advisors. And this is after the court ruled that the appointment of 21 of them was unconstitutional. State House Comptroller Katoo Metito told Parliament in May last year that the advisors earned the same pay as cabinet secretaries and principal secretaries with gross salaries of up to 990,000 shillings. On Thursday, High Court Judge Bahati Mwamuye ordered an audit of all offices under the Executive Office of the President, focusing on those created under the current administration, with a view to abolish any that do not meet the required legal standards. High Court Judge Bahati Mwamuye did not pull his punches on Thursday when he declared the Constitution of Kenya 2010 introduced a clear criteria for appointments to state and public offices to replace the old order of ethnicity-driven appointments, politicization of the public service, cronyism, and recycling of persons who had been rejected by the electorate at the ballot box. Mwamuye concluding in response to a constitutional petition filed by the Katiba Institute in May of last year that the manner in which President William Ruto appointed his over 20 advisors violated not only the Public Service Commission Act and regulations, but several requirements of the Constitution. Justice Mwamuye, for instance, pointing to Regulation 27(2) of the Public Service Commission Act, which stipulates the Commission shall determine the number of advisors who shall be appointed for the President and Deputy President as may be needed for carrying out the functions of office. After assessing several things which are listed in Clause 27 of the Public Service Commission Act, and which include the financial implications of creating the office. But not only was the Salaries and Remuneration Commission not involved, but the requirements of PSC regulations were not met. Regulation 27(6)(1) requiring it to be demonstrated that the technical competencies, skills and experience possessed by the proposed advisor do not exist in the public service. Instead of carrying out its functions, Justice Mwamuye observed that the PSC, based on the correspondence it submitted to the court between itself and the Executive Office of the President, rushed to rubber stamp the appointments, observing that, quote, there are no minutes of commission meetings, no reports analyzing the requests against the criteria in Section 27 of the PSC Act or Regulation 27, no records of discussions or consideration of the financial implications or the uniqueness of the proposed advisor's skills, or an examination of whether there was indeed a gap that could not be filled using internal human resource or human resources from the wider public service. Justice Mwamuye was also not sold on the argument preferred by the Principal Administrative Secretary in the Executive Office of the President, Arthur Osia, that, quote, the appointment of, quote, personal public advisors to the President is an internal administrative staffing matter and not a legislative or major policy decision with general public application. A notion Justice Mwamuye sought to disabuse them of, finding the creation of multiple senior and publicly funded offices within the highest office of the land affects the structure of the executive, has substantial recurring financial costs, and potentially alters the dynamics of policy formulation. It is a decision of high governance and public interest that is very much fitting for public participation. The positions were never advertised. There was no open call for applications, no shortlisting based on objective criteria, no interviews conducted by an independent panel. Specific individuals were simply named by the President's Executive Office and thereafter appointed as fait accompli. His judgment continues to read, the total secrecy surrounding the number, functions and cost of these offices until this litigation for some disclosure is a blatant violation of this constitutional duty. The public had a right to know these details proactively. The respondent's failure to publish them breached Article 35. Former Chief Justice David Maraga joined civil society actors in celebrating the judgment. Posting to his social media, the invalidated advisor positions consumed substantial public funds, and it is only right for those payments to be refunded since the offices were illegal. President Ruto's chief economic advisor, David Maraga, is among the 21 affected by Thursday's decision and immediately responded, "We don't need state offices to advise the president. We supported him for 2 years on the road to victory. We can do it as an informal kitchen cabinet over breakfast every morning." Olive Burrows, Citizen TV.